Hi, Mark Satawa of Satawa Law, and today's video blog is on COVID-19 and compassionate release. The question on everyone's lips right now is, can I use the federal compassionate release statute to get my family member out of federal custody, out of the BOP, because of COVID-19? The short answer is yes. The longer answer is maybe, depending on the specific and unique facts of your case. We have been taking a lot of calls and actually filing these petitions over the last week or two. They're really gaining momentum, and they're being heard by judges. So let's dive into that a little bit deeper. A federal sentence is for the most part not changeable once it's given. Traditionally, the only two ways it could be changed were Federal Rule of Criminal Procedure 35, which allows the government to go to the court that sentences a defendant and said, we want this person released because he's cooperated with the prosecution of others, provided substantial assistance. And the second reason, or second way, was under the federal compassionate release statute. Traditionally, the compassionate release statute was a dead end. That's because in the past, the jurisdiction to rule on compassionate release petitions was with the BOP, who surprisingly never granted them, or rarely granted them. In 2018, with the passages of by the Federal First Step Act, that was changed. Congress put the ability to rule on motions for release under compassionate release with federal judges. So now the federal judges in the district of your conviction can grant a motion releasing someone because of compassionate reasons or compassionate grounds. And right now, the most obvious one of those grounds is COVID-19. When COVID-19 hit, it was a mess for the BOP, and through no one's fault other than the fact that you have a bunch of people living on top of each other. It's just a perfect storm, a perfect cauldron of the spread of a pandemic like this. We have all seen the videos from inmates that have been sent to the outside of the inside of BOP facilities that showed how bad things are in there. And as a result, lots of family members and loved ones are calling about the inmate in their life and asking, can we use this statute to petition for that person's release? And again, the answer is yes. And I guess the longer answer is there's no reason not to try. The compassionate release statute sets out a set of circumstances and requirements that you are supposed to satisfy before you can file this motion. For BOP, for these COVID motions, the two biggest requirements are: number one, you are supposed to exhaust administrative remedies, which means you have to petition the warden, the BOP in the facility that you are housed in, and get denied by the BOP, by the warden. And then secondly, there is a 30-day waiting period. And there's quite a bit of debate going on right now as to whether that waiting period is jurisdictional or not. And for lawyers, that means if it's jurisdictional, it can't be waived. It has to happen. And if it's not jurisdictional, that means it doesn't have to be followed exactly. It can be waived in the right circumstance. Courts are all over the map on this. Some courts in Michigan and federal courts in Michigan and throughout the country have ruled that it's not jurisdictional and the 30 days can be waived. Other courts have ruled, including in Michigan, throughout the country, that it is in fact jurisdictional and can't be waived under any circumstances. The most common reason these petitions are being denied, in fact, at one point, it was well over 45, I think, out of 48 petitions that had been denied were denied because the 30-day jurisdictional waiting period had not been followed. So what do you have to do to file the petition like this? Well, the main issues are, COVID-19 presents a compassionate problem that requires your family member, your loved one's release from custody. The factors that they consider are those that you would probably guess, which are: first, the age of the defendant. Are they in that high risk group of people that if they get COVID-19 are really subject to a high risk of serious illness and death? So age, pre-existing health conditions, diabetes, hypertension, cancer, heart conditions, obesity, lung conditions, asthma, severe asthma, all of those things are a factor. Your odds are increased if it's a low severity offense, white collar offense, non-violent offense. All of those things are in your favor. It's helpful if you've served a majority or at least a substantial period of the underlying sentence, so that the length of time that's being forgiven or you're being released from is less than the amount you've already served. Again, there are other, the underlying facts of the case. I mean, did the person plead guilty? Did they go to trial? Did they provide some sort of cooperation for the government? Again, all the kinds of things that you would normally look at and think would be considerations for this are certainly considerations by the judges. So I guess the bottom line, and for most people, is why it doesn't hurt. It doesn't hurt to try. We are drafting these petitions. Lots of lawyers are. We are having success. People are getting released. And they are working. Not every judge is making you wait the 30 days. And I guess the other part of that is, even if your petition has to sit for 30 days, 30 days from now, the COVID-19 pandemic is probably still going to be with us. And 30 days from now is certainly better than the rest of your sentence. So if you have questions, please reach out to us. It's easy to find us. Our website, protectingyourfuture.info. Phone number 248-356-8320. Email address mark@satawalaw.com. Scary times, folks. So please, everyone, stay safe, be healthy, stay at home. And if you have any questions, reach out to me and reach out to us. We're here for you. Satawa Law, defending your rights, protecting your future. Till next time.